Hello, I'm Jessica Ryan Keeney. I'm an attorney licensed to practice law in the state of California. And the video today is not legal advice. It is for educational purposes only. I'm the Department of Child Support Services attorney for two small Northern California counties. I've been practicing family law since December of 2009. Before that, I was a law student working for a family law attorney. I'm a former city attorney for just under 5 years, and today you will probably see and maybe even hear my son in the background. Hopefully he'll be quiet. If not, sorry. Not a whole lot I can do about it. He got to come to work with me today. So go ahead, like the video, subscribe, ding the bell so that you get notifications when we upload future content. If you have any questions or comments, put them in the comments. If we do answer you, those answers won't be legal advice. They too will be for educational purposes only. Often they make for good video topics in the future. We sure appreciate you being here. And without further ado, what are we discussing today? So this video discusses imputing income in general in California child support cases. When the court imputes income to a party, the court is setting child support as though the party earns an income that the party does not actually earn. And this is often done when a party is unemployed or underemployed or not earning at their potential. Parties in child support cases often want income imputed to the other party, and it's not uncommon for the Department of Child Support Services, also known as DCSS, to ask that income be imputed to one or both parties. This video looks at the requirements for the court to impute income to a party. So first we'll look at the statute. Family Code Section 4058B reads as follows. The court may, in its discretion, consider the earning capacity of a parent in lieu of the parent's income, consistent with the best interests of the children, taking into consideration the overall welfare and developmental needs of the children and the time that the parent spends with the children. So that's what the statute says about imputing income. You'll notice it doesn't actually use the word impute. And let's see what the case law has to say about imputing income, because that adds some more explanation to the statute. Let's see. Citations to the case law and to the family code are going to be in the description below. Always go look at the description. It has good information for you. And I'm not going to read the full citations to the cases because, oh my gosh, they're long and they're boring. And you can go look at the description to see those. And I like to provide citations to the statute and the case law so that you can go read for yourself. Because every time I come across somebody on the internet answering a question and not citing the law, I think, cool story. But what does the law really say? Because I would like to go read it for myself and see, and I want you to be able to do that as well. Okay, so Marriage of Berger is a case in which father held a high-paying job in the financial industry. He voluntarily quit that job and started working for a landscaping business that he was part owner of. He made substantially less money in this job with the landscaping company and chose to have part of his income reinvested into the company instead of take it home as income. Mother wanted the court to impute income to father based on his high earnings in the financial industry, and father wanted the court to base child support on what he was actually taking home as pay from the landscaping company. The California Court of Appeals held income cannot be imputed based on a party's earning capacity, absent proof of both the ability and opportunity to earn the income on a going forward basis. As the court recently explained in Marriage of Berger, sometimes I mispronounce things too, sorry. The burden of proof for imputation of income cannot be met by evidence establishing merely that a spouse continues to possess the skills and qualifications that had made it possible to earn a certain salary in the past, even where it was undisputed that the spouse had voluntarily left that prior position. The court found that there was no evidence that father could earn income at the rate he did before going to work with the landscaping company, and so did not impute father's income from the financial industry to him. And the court found, and that last one, when I said the court, I meant the Court of Appeal. The Court of Appeal found that there was no need to impute income to father because he had an established salary level from his current services at the landscaping company. He simply chose to, in the words of Labasse and Muncie, divest himself of those earnings for reasons unrelated to his family or their needs. So the court reversed the order of the trial court and ordered the trial court to recalculate father's support obligations at a level commensurate with the earnings he was voluntarily, or that he had voluntarily chosen to forego in pursuit of his landscape business dream. So to summarize, the court cannot impute income to a party without finding that the party has the ability and opportunity to earn that income. Additionally, evidence that the party has the skills and qualifications that made it possible to earn a certain amount of money in the past is not enough to meet the burden of proof that the party still has the ability and opportunity to earn the salary now. This applies even when a party voluntarily quits working. Additionally, if a I'm having trouble today. Who am I kidding? I'm tongue-tied in every video. Additionally, if a party voluntarily defers his or her salary instead of taking it home as income, the court can set support based on the salary being deferred. And that's exactly what the court did here. So the reason why I like this case is because it gives a clear and concise statement of what the court needs to impute income, but then it also shows an example where the court chose not to impute income because they didn't have to. Dad was actually earning a salary. He was just choosing not to take it home. Next, we have McHugh v. McHugh, aka in Remarriage of McHugh, and this is a case in which father lost his job due to misconduct committed specifically in an attempt to lower his child support obligation. The question the Court of Appeals considered is if it is proper for the court to impute income to the parent earned from the former job. So father asked the trial court to lower his child support because he lost his job as a commissioned salesperson and his new job paid a lot less. Father lost his job because he was diverting business from the company he was working at to his father's company. He was selling goods to customers directly, bypassing the company he worked for, and he declined to participate in the company's offer to keep him as an employee if he completely disclosed his misconduct and paid the employer restitution. And he did this to minimize his support. Father started this misconduct after asking his employer to help him decrease his income because he was in the middle of a bitter divorce. The company declined father's aggressive suggestion of diverting some of his income, but told father that he could be assigned to a lower paying position. And father declined the lower paying job and stayed in the higher paying position and did those bad things that we just discussed. In relevant part, the Court of Appeals held, we affirm the trial court's order exercising its discretion to impute income under Family Code Section 4058, Subdivision B, because substantial evidence supports the findings that father had the ability and opportunity to keep his job. His termination was a voluntary divestiture of resources required for child support obligations because of his misconduct in diverting business to his father's company to avoid his support obligations and deliberately failing to satisfy his employer's conditions for keeping his higher paying job, and imputing income to father was in the best interests of the children. Here, the holding of the court is super clear, so there's really no reason to reiterate what the court said. And, when discussing somebody voluntarily committing bad acts to avoid child support, or voluntarily quitting a job to avoid child support, or voluntarily lowering their income to avoid child support, I'm frequently asked, well, how do you know they're doing that? And a lot of times people will admit that's what they're doing. They'll tell their buddies that that's what they're doing. Or like in this case, they'll ask the employer for help to lower their income. And so a lot of times we end up bringing in witnesses who testify that that's exactly what the party paying support said. It was that they were going to lower their income to avoid support. I don't know why people say things like that, but trust me, they do. So next we have Marriage of Simpson, and this is a case in which the supporting parent worked an excessive amount of overtime during the marriage to increase the marital standard of living, then stopped working overtime after the parties separated. And this was to spend time with his children and have a less stressful life. That's what he said. And the court believed that's why he did it. The Supreme Court of California looked at the issue of should the court impute income based on a rigorous work schedule with a lot of overtime. So during the marriage, father worked an excessive amount of overtime as a theater stagehand. After the parties separated, father left his job as a theater stagehand and started working as a stagehand for television studios. He also quit working excessive amounts of overtime. He did this because it was less stressful and he could spend more time with his children. And that's really common to see in a divorce, is to see someone who worked a bunch of overtime, then they get divorced and they stop working so much overtime. And I see that a lot of times in 50-50 custody cases, because now the parent who is working overtime has 50% responsibility for the children. They need to work less overtime so that they can help take care of the children. So what father did here, super common from what I see in divorces. Anyway, when father did this, he earned less money and he wanted support based on his actual income. Mother wanted support based on what father was earning when he was working an excessive amount of overtime. I've got to say, I also frequently see people continue to work a bunch of overtime after the divorce, but they always say, overtime's not guaranteed, but that's another topic altogether. That's not what we're dealing with here. So in relevant part, the court held, we conclude that earning capacity generally should not be based upon an extraordinary work regime, but instead upon an objectively reasonable work regime as it would exist at the time the determination of support is made. See Marriage of Smith. Such a conclusion is compelled by equitable considerations and is consistent with the legislative policies enumerated in the statutes governing family support. Setting support at a level which contemplates a work regime considered extraordinary under current societal standards is contrary to Section 4801's guideline authorizing spousal support that is just and reasonable, and Section 4720's guideline authorizing child support according to the parent's circumstances and station in life. The court further stated, we conclude the record fails to, well, I guess they further held, we conclude the record fails to establish the trial court properly determined father's earnings capacity in accordance with the standard of the objectively reasonable work regime. The court held that earnings capacity should not be based on an extraordinary work schedule or excessive overtime. Now, this is different than a situation where a party continues to work a lot of overtime, and I see this a lot with correctional officers. They tend to work a lot of overtime. And so that's not a situation where they continue to work a lot of overtime where the court's imputing income. That's a situation where the court is setting support based on the actual income, including the overtime. So in this case that we just discussed, we have somebody who worked a bunch of overtime due to new circumstances in his life. He couldn't work so much overtime, so he stopped working all the overtime. He needed support based on the amount of income he was actually making without the overtime, and mom didn't want the court to do that. Whereas when somebody continues to work a bunch of overtime, the court's going to look at the fact that the party keeps working a bunch of overtime, and they're going to set support based on what's actually been happening. And I frequently see the court use a 12-month average in those circumstances. But I know it might seem a little bit tough to understand sometimes, but that's a situation where the party continues to work an excessive amount, as opposed to this case where the party didn't continue to work an excessive amount. Hope that makes sense. Okay, in Marriage of Berger is a case that looks at who has the burden of proof when the court is asked to impute income to a parent. So mother and father had 2 teenage boys. One of them was special needs. Mother and father were both deputy sheriffs and made relatively the same amount of money. Mother and father separated and shared 50-50 custody of the boys. Because of their relatively equal income and equal timeshare, they had a $0 child support order. Mother retired when she had 20 years of service at her job. However, she was only 42 when she retired. Custody changed and father ended up with primary custody of the special needs child, and the parties continued to split 50-50 custody of their other child. Father wanted child support from mother based on the amount of money she made before retiring. In relevant part, the Court of Appeals held the following. If one parent seeks to modify an existing order so as to have income imputed to the other parent, the parent seeking imputation, that is, in that context, the parent seeking to overturn the status quo, which in this case was father, bears the burden of proof of showing that the other parent has the ability and opportunity to earn that imputed income. So in relevant part, the Court of Appeals stated the following. However, other than presenting evidence of what the mother had been making at the time of her retirement, the father presented no evidence of her vocational abilities or of any opportunity she might have to earn additional income. The father didn't, for example, show that the mother even could go back to work as a sheriff's deputy, or that there were opportunities for her to work in related fields. Conspicuously absent are the sorts of things that helped parents seeking imputation to carry their burden in Heinemann 8. Had to count the little I's after the V there, and with Labasse and Muncie, e.g. the imputee's resume want ads for persons with the credentials of the potential imputee, opinion testimony, e.g. from a professional job counselor, that a person with the imputee's credentials could readily secure a job with a given employer or set of employers, or pay scales correlating ability and opportunity with the income to be imputed, nor were there any vocational examinations. So basically, in this case, dad didn't meet his burden of proof. He presented no evidence about mom's ability and opportunity to earn at the income that he wanted imputed to mom. And so the court didn't impute income to mom. So this case illustrates that one thing a party may do to prove ability to earn a particular income is present evidence of the job skills of the party to which income is requested to be imputed, aka the imputee. This may be in the form of a resume, a vocational evaluation, testimony of a party about their job skills, and past jobs held. This also illustrates that one thing a party may do to prove opportunity to earn a particular income is present want ads or job postings for job openings seeking people with the job skills that the imputee has. Another case is in Marriage of Berger, and this is a case in which the bad behavior of a parent caused the parent to lose his job, but the parent wasn't trying to avoid his child support obligation. He was just being bad at work. The court answered the question, should father's income from the job he lost be imputed to father? So father made a decent income as the director of legislative and local government affairs. He was fired from his job due to misconduct. He was subject to child and spousal support orders when he was fired from his job. Father's misconduct was not a result of him trying to avoid his child or spousal support orders. His misconduct was that he sent sexual emails to a coworker and he used the work computer system to do so. So father filed a motion to lower support based on his decrease in income. The trial court denied father's motion. Basically, they did this because it was father's bad behavior that caused him to lose his job. Essentially, the court imputed father's lost income to him even though he no longer made that income. The Court of Appeals held in Marriage of Padilla, a parent's motivation for reducing available income is irrelevant when the ability and opportunity to adequately and reasonably provide for the child are present. The court further held, when a supporting parent loses a job, the trial court may impute income to that parent based on his or her earning capacity if the amount of income imputed is supported by evidence of opportunity and ability to work reflecting that level of income. The court cited Vargas, in which the Court of Appeal concluded that the trial court erred by automatically imputing the minimum wage to a defendant without considering opportunity and ability to earn income while incarcerated, stating if appellant does not have an opportunity to work, whether in prison or not, the earning capacity test is not satisfied and cannot be used to determine his child support payments. The court additionally held, in this case, the supporting parent lost his job, but due to misconduct. There may be situations where the supporting parent's conduct warrants considering a claimed involuntary termination of employment as actually voluntary for purposes of determining the parent's earning capacity. We conclude that on this record, however, the trial court erred by so construing the termination of employment as voluntary, where defendant's employment was terminated for using extremely poor judgment in sending multiple emails that were sexual nature to a coworker. So the trial court's order was reversed and the matter remanded. There may be situations in which it's appropriate to impute income at the old level to a person who was fired from a job. However, this was not one of those situations, and that's because there was no evidence that father got fired from his job as a way to avoid his support obligation. And there was no evidence that father still had the ability and opportunity to earn income at the level he earned at his old job. And so compare this to the other case we discussed in which father committed bad acts and lost his job. In the first case we discussed, father specifically committed those bad acts and lost that job to avoid his child support obligations. Whereas in this case, dad committed bad acts and lost his job, but there was no evidence that he did it to avoid his support obligations. So that's why the court did not impute income to dad in this case. So we look at earnings capacity, ability and opportunity to earn, and of course the best interests of the children. So Family Code Section 4058B allows the court to consider the earning capacity of a parent when setting a child support order. The case law cited above establishes that earning capacity consists of the ability and opportunity to earn at a certain amount of money. Who has the burden of proof? Well, the party asking that income be imputed has the burden of proving that the imputee, that's the party to whom income may be imputed, has the ability and opportunity to earn the income that they're asking to be imputed. What are the ways of showing ability and opportunity to earn? Some of the ways to show the court that a person has the ability and opportunity to earn a certain income are to present the following. Present a resume of the imputee, have the imputee take the stand and testify about his or her job skills and education, have a vocational evaluation done on the imputee and have the vocational evaluator testify about the job skills and education of the imputee as well as the job market for people with the skills and education of the imputee. Present job postings or want ads for jobs looking for people with the skills and education of the imputee. Present pay scales for jobs requiring the skills and abilities of the imputee. So there you have it. That is imputing income in general in California child support case. This was not legal advice, but we sure appreciate you tuning in. If you have any questions or comments, put them in the comments below. Any answers will not be legal advice, but they make for good discussion, good education, and they sometimes find their way into a video. Go ahead, like the video, subscribe, ding the bell so that you get notifications when we upload future content, and stick around because this imputing income is going to be a little mini series that we do. So the next video in the works is about imputing income to the custodial parent. I have heard judges and attorneys say that income cannot be imputed to a custodial parent, and that just plain is not true. The court has discretion to do that, and the next video is going to discuss that. And there will be at least one more video after that. There might be two. So stay tuned. Thank you so much. Have a great day.